FATIHAH binti ROSLAN. So I'll be doing this video presentation together with my other two group members. So basically, this video presentation will be divided into 3 parts. The first parts will be delivered by me. The second parts will be delivered by NURUL binti Mohd Sabirin, and the last part will be delivered by FARAHANIS NABILAH binti Mohd AZIRAN. Why Sexual Harassment Act? That will be the first question and relevant to us. Frankly, there will never be a precise answer on that question because it's so impossible to answer it comprehensively and fits the first idea that comes to people's mind when they first heard about it. Briefly touch on the skeleton, this act consists of 5 chapters, namely preliminary, offences, accountability, punishment, and other pertinent matters. However, I will only explain on chapter 2 concerning offences. What kind of acts or gesture, be it verbal or physical, that will fall within the ambit of sexual harassment provided in this act. This particular chapter are divided into 2, which what forms of act may constitute an act of sexual harassment, and another provision will illustrate elaboratively circumstances that is equated to sexual harassment acts. Crucial to note that these circumstances drafted may not be exhaustive and may not cover everything that is possibly regarded as sexual harassment. Thus, flexibility clause in these provisions exhort the court to interpret these provisions using a liberal approach, which Sexual Harassment Act is not confined to those provided in this provision. For the jurisprudence analysis, both provisions inserted in Chapter 2 are mainly based on sociological school of jurisprudence. As far as concerned, sociological school of jurisprudence talk about social phenomena where the law itself derived from the society, the people, not from the legislation. Meaning to say that law is formulated to govern the behavior of the society. It works as a social institution where it will impact the society's level of discipline. Back to our provisions of the Act, it is an attempt to address on how sexual harassment acts might have occurred, which adversely affected the victims physically and mentally. These issues emerge from people, therefore, law must work as a vehicle of social institution to respond to this issue, salvaging the affected people by satisfying the need of law presents to fix the issue regardless of genders and other related incidental matters in a way to include all probable acts to be regarded as sexual harassments, which will qualify those offenders to be legally sanctioned. Essential for me to highlight that the flexibility of these provisions is made purposely as this act is subjected to social changes, thus law enacted must always be adaptable despite any changes occur. Or if I could characterize it, it will incline to be a timeless law which is not restricted to a particular period of time, which might be irrelevant or harsh. In other words, if it's so rigid, then it will not respond to social issue appropriately, and it might be too obsolete to respond to those issues. Furthermore, this is what it means by one of the famous scholars of sociological school of jurisprudence, which is ROSLAN, as law made on sociological approach is an instrument to either balancing the conflicts or completing interests of people in the society. Putting it into perspective, the interests of the affected people suffering from sexual harassment must be upheld as their dignity are oppressed due to such acts. Therefore, law will come into play, defending the rights of the victims by taking legal action to the offenders, humbling them down, impliedly saying both offenders and victims' interests are balanced through the legal actions. Talking about the Western jurisprudence, then we shall move on to the Islamic jurisprudence. It is alleged that Islamic jurisprudence also assimilated in these provisions enacted in Sexual Harassment Act. Those provisions in Chapter 2 is enacted to elaborate on how sexual acts might occur within society and in what form sexual harassment can appear. Islamic law can be derived either by primary sources or secondary sources consisting Quran, As-Sunnah, Ijtihad, Masalih Mursala, Istishab, and others. On that note, these provisions enacted based on Hadith and the Sunnah. This is substantiated by, there is an Hadith by Tabarani saying that if someone's head among you is stabbed by the iron needle, it's better for you rather than groping a woman who is not his own wife. And another Hadith, if you welted with the pit covered in mud and dirt, It's better for you rather than you lay on your shoulder to another woman's shoulder who is not your wife. Both hadiths picturize that sexual harassment or violence are disgusting and strictly loathed in Islamic perspective. Though this hadith it seems to address when the sexual violence happen towards women, but it must be bear in mind Quran advocates equality between all and says that the only good deeds may raise the status of one human over another. In Surah An-Nisa, verse 1 to 4 narrates that both men and women are spiritually equal. There is no such thing as restricted to only one gender and inclined to commit an indecent act. But probably around that time, there is so much oppression towards women, thus explaining why this hadith specify only one gender, which is women as a victim. However, in the present context, sexual harassment could happen to anyone.
This chapter consists of 4 sections, where first section, section 6 of these provisions, provides who can be the victim of the sexual harassment. Apart from that, under this chapter also, we provide the procedure that can be followed by the victim in order to lodge the report. This can be seen through section 7 until section 9 of the Sexual Harassment Act 2022. In my opinion, this provision was in line with the principle that being emphasized in sociological jurisprudence. Why I said sociological jurisprudence? This is because the basis of the sociological jurisprudence is to study law in its social settings. In other words, it can be said that sociology is the science of human behavior. Thus, the principle of the sociological jurisprudence examines the actual behavior of the people, including such as judges, advocates, even the criminals and citizens, while they enacting the law. The famous scholar of this school of jurisprudence is Max Weber, that by examining the way in which the actual behavior of people, we can reach the ideal norm of the legal system. This is what actually we do or consider while we enacting this provision or this law. While in the process of enacting the act, we found that the sexual harassment doesn't occur only among the women or between an employer and an employee only. In fact, it can be happen to everyone, despite of their gender, their age, their citizens, non-citizens, their races and whatsoever, or whatever job you are doing it can be happen to anybody. For instance, it can be simply happen while even you are having a chit-chatting with your friends. Thus, by examining the behavior of the society nowadays, we come up with this provision that covers the victim can be any person in Malaysia, despite of their background, despite of their gender, age and their races. Besides, the sociological jurists also believe in the solidarity of the society. This can be seen through their famous scholars known as Emil Durkheim, where he gives primacy to society rather to individuals. He regards society as an independent entity holding power over individuals. And this is what we practice while enacting this provision under Section 8 of the Sexual Harassment Act 2022, where we can see this provision allows other person to lodge a report on part of insane person. We believe an insane person also can be sexually harassed, and thus the society can help them through their personal representative, such as their personal representative which had been appointed by the court, or even their solicitor. Other than that, we also follow the theory from the natural law, where this principle believe that law and morality cannot be separated and it was connected to each other. And according to Aquinas, theory on natural law is good is to be done and evil is avoided. This is because he believed that it is the fundamental principle to maintain the morality in the law. I believe that sexual harassment was totally against the principle of natural law, and thus we need a law of provision to ensure that it will protect one's right to life in the sense of their dignity and their reputation. Referring to the provision that had been enacted under Chapter 2 of the Sexual Act 2022, it suits with both of Islamic jurisprudence and Western jurisprudence. Under Islamic jurisprudence, it suits with the principle of masalih mursalah, where masalih mursalah literally can be understood as consideration of public interest, or it also can be referred to as securing benefit by removing the harm. According to Imam Al-Ghazali, the benefit that intended by the lawgiver for mankind in preservation and protection of their religion, life, reason, lineage, and property is in accordance with the Maqasid Sharia, thus protecting the victim of sexual harassment and providing a clear procedure to charge someone as committing sexual harassment in order to prevent from falsely accuse any innocent person or any innocent people. It can be said securing benefit by removing the harm. Thus, this provision treats everyone equally to secure their benefit, which their dignity and their life in line with the Maqasid Sharia. Allah also said in Surah An-Nisa, verse 124, this verse advocates that equality between all and says that the only good deeds may raise the status of one human over another. Thus, it can be said that what had been opined by the Islamic jurists, which had been derived from the divine authority, was in line with the Western jurisprudence. The Western jurisprudence, such as sociological jurisprudence, tends to say examines the actual behavior of the people while enacting the law, and that same goes to the principle of masalih mursalah. The authority provided based on the current situation of the society and ensuring that the society will get benefit by removing the harm, and that also what had been practiced under natural law, where they emphasize that law and morality cannot be separated. Same goes to what had been practiced under Islamic jurisprudence, where whatever law that had been enacted, it must be based on the Maqasid Sharia. Thus, I believe that this provision under Chapter 2 of Sexual Harassment Act 2022 really suit and in accordance with the principle of Western jurisprudence and Islamic jurisprudence.
On my part, I've been assigned to talk about two chapters. Chapter 4, the punishment of sexual harassment, and Chapter 5, the duty to ensure an environment free of sexual harassment. In this video, I intend to create an understanding of the necessity of this act along with the philosophy of Western and Islamic jurisprudence which are relevant. So let's get into Chapter 4. Section 10 of Sexual Harassment Act 2022 provides that whoever sexually harass any person within the meaning of this act shall be punished for imprisonment not extending to 7 years or fine not extending to 10,000 or both. Next, Chapter 5, under Section 11 of Sexual Harassment Act 2020. It echoes the duty of a person in charge in any institution, schools, workplace, organization, or a public place to ensure an environment free from sexual harassment. Moving on to the next part of this video, which I will discuss the relevance Western School of Jurisprudence that pertinent to this act and what provision represents the school's view. Let's start with the Positivism School, which view law as what it is and not what it ought to be. Besides, the other positivists, Jeremy Bentham, interpret law based on principle of utility and theory of pain and pleasure. In short, it means that the subject matter of law is the community and their interests will be preserved. So, the community's happiness will become the priority in the question of law, and law act as a tool to achieve the community's maximum happiness and pleasure. Based on both chapters, the law achieved the Jeremy Bentham's philosophy based on two reasons. First, it will bring the satisfactory to the community and to the victim, since there is no existing law connoting the rights and punishment to safeguard the victim of sexual harassment. Second, the existing law under sexual harassment in the workplace and some provision under penal code is limited and blurred. As a result, the imposition of punishment and the obligation to ensure the place free from the crime will bring maximum happiness to the community. Now I will explain the reason why we put the provisions in the Act. For Chapter 4, the punishment, we try to convey that any person committing sexual harassment deserves to be punished. The existing law under penal code is very limited to what constitutes sexual harassment, such as any act or intent to outreach the modesty of the person, and is very limited to scope of application. Section 509 only provides imprisonment for not extending 10 days and not extending fine for 20 ringgits. Not to mention, Section 81C of the Employment Act only empowers the employer to dismiss, downgrade, or to terminate the employment. This is unfair to the victim because they need to bring a separate action to convict the wrongdoer in court.
To conclude, punishment is relevant to give warning to the community worldwide that the heinous act has its consequence. Additionally, the reason why we put Chapter 5 in our act is because to create a place that has minimum threat to our safety. The victim constantly receives backlash from doing what is right, necessitates the person in charge to create an environment free from discrimination. This is because the offender tends to be manipulative and hides from its true color, and the people surrounds us inclined to not believe the victim, especially the woman. So the person in control have to take necessary steps in ensuring the safe place for the victim also. Moving on, this part of this video will talk about the correlation of the provision with Islamic jurisprudence. Under Chapter 4, fiqh or Islamic jurisprudence often described as human understanding of the divine Islamic law as revealed under Al-Quran and As-Sunnah. Is a law revealed by the God to its believers. In Sharia, sexual harassment is strongly prohibited because it degrades human's dignity. In a hadith, Prophet Muhammad, peace be upon him, said that if you welted yourself with a pig covered with mud and dirt, it is better for you rather than you lay your shoulder on another woman's shoulder who is not your wife. Hadith riwayat Tabrani. We can see that Islam also considers sexual harassment as an offense and it has repercussion. The punishment of this crime under Islam is prescribed under ta'zir punishment, which is upon discretionary of the authorities because it excluded from the punishment under hudud or qisas. For example, Sultan Ottoman had enacted law known as qanuns. It relates to the ijtihad, which is another branch of Islamic jurisprudence. So the ijtihadis will discuss and determine the suitable punishment for the offense after reaching a consensus agreement. Moreover, the correlation between Chapter 5 with Islamic jurisprudence can be seen in several hadiths which promotes to safeguard one's man's honor. Prophet Muhammad, peace be upon him, stated that whoever saved the honor of his brother, Allah will save his continuance against the blaze of fire on the day of judgment. Clearly, this hadith promotes the responsibility of the Muslim to preserve his brother's dignity, modesty and honor. It is not to invite any evil intention among the Muslims to maintain the peace. It is corroborated with the provision to necessitate the person in charge to create an environment free from sexual harassment. In conclusion, sexual harassment is not a battle of the gender. Women are no longer perceived as the only victim in this crime because both genders are capable of harassing. In fact, harassment can be happen between same genders. This enactment will help to spotlight the voices to have a proper statute in administering the sexual harassment in Malaysia. It is to confer right to the victim, obligation for certain bodies, and the punishment to the offenders. The scope of conviction also becomes broader because it includes an almost conclusive definition of sexual harassment which can be picturized in various circumstances under this act. Likewise, from the perspective of positivism, sociologists and working legal theorists supports this motion based on different point of view. Not to mention, Islamic jurisprudence has been long advocating the prohibition of sexual harassment in Al-Quran and As-Sunnah.